Well, welcome everyone. I'm Sharon Prepper Weisbaum, and I am the managing partner here at Brown Goldstein and Levy. Our firm has a long history with PJC from since its founding, and we welcome PJC back in person and on Zoom. We've been having these breakfasts here pre-pandemic for probably the 10 years prior to have these wonderful speakers, and then we had this gap, and so we were thrilled when you all asked to come back in person. And I know we have a lot of Zoomers, so anyway, I'll turn this over to John or whoever from PJC is introducing, but welcome, and we look forward to more events with you all.
Thank you so much. I'm actually going to turn things over to Janice, our executive director, to kick us off this morning.
Good morning. It's great to see everyone in this hybrid model that we're in. And I am excited to be celebrating 20 years of progress with NCCRC and the subsequent and resulting expansion of right to counsel, all over the country, and particularly here in Maryland. So I'm Janice. I'm the executive director here at the Public Justice Center for about 1 year. I'm excited every time I have a chance to talk to folks about the work of the Public Justice Center. I tend to go on and on. So I'm going to rely here on my notes to keep us on time and on track, and be sure to turn it over to John, Maria, and Amanda so you can hear the really impactful and incredible work the project has brought us to, and where they're looking at, maybe for the next 20 years. Since 1985, the Public Justice Center has worked to build a just community through systemic change. NCCRC is, a prime example of that. But you can learn more about the Public Justice Center and all of our projects at publicjusticecenter.org. There you have an opportunity to do a few things. You can join our mailing list. You can see the links to follow us on Twitter and Facebook and LinkedIn, and certainly learn more about what we do as an ongoing project and concern. So big thanks to Brown Goldstein and Levy for hosting the in-person component. Thank you guys so much for continuing to be such a strong partner with the Public Justice Center over these many years. I say that we are close relation. It's the kith and kin in the public justice work, certainly in public interest law. Our partnership with Brown Goldstein and Levy is key to our success. So thank you guys again for continuing to stick in there with us over these years. So I'm going to say a list of thank you to NCCRC funders. And knowing that this project goes back 20 years, we've had huge support from foundations, individual donors over the years, fee-for-service contracts, community folks, volunteers, coalition folks. So thank you all in particular, but certainly I want to make sure to run down this list of current funders. We have the American Bar Association, the Bigglesworth Family Foundation, Bunting Family Foundation, Equal Justice Works, the Charles M. and Mary D. Grant Foundation, International Academy for Trial Lawyers Foundation, JPB Foundation and New York Law School, Results for America, Venable Foundation, Vos River Charitable Fund, the Beaumont Foundation City Health Program, and other incredible individual donors. I certainly want to be sure to thank PJC staff, particularly Becky and Kathleen, that works so hard behind the scenes to pull these events together. Thank you both. Any board members, former board members, Lawyers Alliance folks, and Leadership Council folks that are with us today, thank you for continuing to support PJC and our vast number of projects and programs over the years. And with that, I'm going to turn it over to John, Amanda, and Maria. It's the dynamic trio who have that are they're running this whole thing all over the country, that are in town with us for a few days. So we're excited to have them in person here with us for a few days. With that, I will flip it to John.
Thank you so much. I'm actually going to flip it right to
Yeah.
Maria. Just that's how we roll here.
We're gonna go through a couple of acknowledgements because it is our 20th year. So just a big applause. Thank you, Janine. It's a really big achievement. We've really come just very far in the coordination around the Civil Rights Council across the country. I know many of you have been involved in it from the very beginning and have known about it from the very beginning. And so it's really exciting to be here. I'm going to run through the agenda really quickly, and then we're going to get started with the presentation. We're going to leave, right? So today, what we're going to cover with you all, we're going to start with a little bit of background so we can all get situated. We can all kind of contextualize this conversation in the access to justice crisis. We're all kind of familiar with it and work in it. We're going to talk a bit about advancing the Civil Rights Council, why that matters. And then we're going to touch on work that we are doing. I mean, the biggest portion of the work that Amanda, John, and I do for the National Coalition right now revolves around the right to counsel for tenants facing eviction proceedings. And that movement is exciting. It is inspirational. It is ever growing. We are constantly inspired by the folks that we work with and hope that we can relate that to you all today. We're going to look a little bit ahead, and then we're going to leave some time for questions and answers. I do have to say, if you don't have any questions, I have questions for you. So prepare yourselves. But I'm going to hand it to John to do a couple of acknowledgements that are really important to us. And take it away.
Thanks so much. And we actually should just take a moment to, I'm John Pollock. I'm the coordinator of the National Coalition for Civil Rights Council. Maria Rumiansova is the associate coordinator, and Amanda Enzlako is our legal research specialist. So our really amazing team, really thrilled to be with you today. As Janice said, we have some great funders. She actually acknowledged them already. This is actually a list, we wanted to just make sure we took a moment to do that. We're really thankful to Brown Goldstein Levy for hosting this event, and which they've done for a very long time. And also just wanted to throw out a thanks to we have a new steering committee at the National Coalition. After many years, we've completely revitalized it. We're looking forward to the work that we've got ahead for the next 20 years. So we have a lot planned, and this year is going to be a really big year for the coalition. Got a lot of stuff coming, new products that we've been working on for quite some time, a new website, lots of stuff in this 20th anniversary year that you should all be really excited about. I wanted to take a special moment to recognize a couple of things before we get started. One is a lot of the work that we're doing now would not have been possible without the American Bar Association's early support of the right to counsel. We have joining us today, Mike Greco is on the Zoom, and I just wanted to acknowledge that his early leadership back in 2005 led to the ABA passing a resolution in support of the right to counsel in civil cases involving basic human needs. That resolution really galvanized a lot of the early activity around right to counsel. It got some of the access to justice commissions to create right to counsel committees. It got the state bar associations interested. It was endorsed by like a dozen or more state and local bar associations, and it really did make a lot of that happen. And Mike was the president of the ABA at the time and was really the driver of that force. So we're incredibly grateful to Mike in his work on that, his personal support of the coalition as well, both personally and professionally. And the ABA did more than that too. They actually funded my position when I started on the section of litigation for 3 years, and actually has given to help us redesign the website. So just really, we're so appreciative to the ABA for all of that work, without which we wouldn't be here today. I also wanted to take a moment. We have Delegate Sandy Rosenberg with us today, who is also one of our really significant champions. Like Mike, both personally and professionally has supported the coalition, is a leader on right to counsel in Maryland, has brought bills, has fought for them, worked very closely with the Public Justice Center on a number of issues, not just right to counsel, for a very long time. And I invited Delegate Rosenberg to just say a couple words, if you would, about sort of his perspective from Annapolis, like how he sees this. So thank you so much for joining us today.
My pleasure. And John, thank you for those kind words and a little bit of an insight into the current activities of what you're doing and what lies ahead. I would summarize what I'm about to say by invoking Rahm Emanuel, who said, "Don't let a crisis go to waste," because that's how we were able to enact access to counsel, not right to counsel. That was a distinction that had to be drawn here in Maryland. We had a series of work groups. I most prominently remember one that I served on along with Steve Sachs, where we were anticipating a Anthony Brown governorship, which would fund the recommendations of our work group. And as I assume most of you know, there was no Anthony Brown governorship. There's now, good fortune, an Anthony Brown attorney generalship. But we sort of figured we were on hold, or we no longer had a governor who would take the initiative and put in his budget funding for right to counsel in housing court in rent cases in line with the recommendations of the work group that we would have had Anthony Brown been elected. But we kept plugging away. And then with the pandemic, Speaker Jones, Adrian Jones on the House side, included within her response to the pandemic, in light of as everyone around this table, virtual and otherwise, knows, in light of the impact of the pandemic on evictions and actions being taken elsewhere by the federal government, she supported the right to counsel. And that was crucial in getting the bill through the legislature. That would have been 2 years ago. And so we took advantage of that opportunity. And you certainly don't want that to happen again. And I'm not saying that that's the only way you can enact access to counsel, right to counsel. That was the case here. But I guess the broader point I would make would be, hopefully there's something you can piggyback on. Another issue regarding vacancies, regarding evictions, that could be the fulcrum for moving forward in another state. As an update, we still have the issue of funding on an ongoing basis. On a temporary basis, it's through the Unclaimed Property Fund and those proceeds, and we're going to continue with that, or seek to continue with legislation this session. I would just add that in Maryland, Attorney General Frosch brought a lawsuit against a legal entity controlled by the Kushner family that owned apartments in the Baltimore metropolitan area. Brought an action, Frosch did, under the state's the safe housing, adequate housing provision of our consumer protection law. And I introduced legislation that would provide that any settlement from any lawsuit brought under that provision of the law, not just the Kushner entity, would go towards the fund that provides counsel for tenants in housing court. There is a settlement. It's $2.4 million going to the state, and that will result in close to 3,000 tenants getting assistance in court. So that is a real life example of pulling different things together to provide counsel. You not only do you have to create statutorily the right, you got to fund it. And there's a bit of an irony in the Kushner family making counsel available to nearly 3,000 tenants. But that's how a bill becomes a law. So that's what I would add. It's up to you, John, if you want me to take any questions, but my pleasure.
Thank you so much. And, you know, I know you have to leave at 10. If folks have questions, feel free to put them in the chat and we can try to get those maybe answered that way. And we will be reaching out to you because there's now a foreclosure right to build council bill that's been filed in Maryland, and we need to talk about that. So
Absolutely, absolutely.
looking forward to the continued work. Thank you so much.
Pleasure.
So I'm gonna get us started with just really briefly, like talking about what the NCCRC is. We're gonna get it more into that a little bit in more detail later on, but what are we? We're a project of the Public Justice Center, and we've been housed under the Public Justice Center for quite some time. PJC was one of the founding organizations of the National Coalition for Civil Rights Council, but the NCCRC, like who we are and what we do, our mission right now is really to support and encourage that advocacy around the right to counsel in civil cases. We're basic human needs, so we're talking about things like shelter, sustenance, health, custody, where those basic human needs are at stake and folks don't have counsel. We're advocating for those efforts on the ground to enact right to counsel law, to implement right to counsel effectively, sustainably. That is our job. That's what we do day in and day out, and we do it on multiple fronts and in various ways. We have our own website, which is civilrighttocounsel.org. We maintain the only map that gathers all of the civil right to counsel research right now and track that, provide status on the map that's available on the website. All of this is going to shift hopefully this year as we change what the website looks like. So as we grow into our 20th year, the website and the way that we present ourselves to the world is also shifting, which is super exciting. We also just those kind of pictures on the screen that you're seeing right now. So not only do we track the map, we also have, or we have the map, we also have a really comprehensive bibliography of all of the things that articles, reports, all of the research that's been written about the civil right to counsel, which is actually really critical. It's one of the founding concepts of the National Coalition is right to coordinate, pull it all together, have that one spot, that one place where people can go to find out how have others done it? What are the concepts involved in the right to counsel in civil proceedings? Why aren't we doing it the same way that we do it in criminal cases? What is the difference? Why do we advocate a little bit differently? So today, we have grown to over 600 participants and partners. Those are folks that are on, that we regularly collaborate with, and that's across 45 states right now. We also, I mean, we deal in other states, but those are really our participants, our partners that we collaborate with often. And I think right now we're going to transition into kind of running the presentation about what we want you all to take away from here. So I'm going to kick it to John to talk to us a little bit about why, why all of this, why have this project to begin with. And we're starting with the access to justice crisis.
Yeah, so we know, you know, many or most or maybe even everyone on here is aware that there has been a longstanding access to justice crisis. That's not news. You know, but when you look at it in specific context of the right to counsel, we basically start with really, really bad case law from the Supreme Court, which set the tone back in 1981, and then reinforced it again, actually in 2011, in which the court has said there's no right to counsel when someone's parental rights are being terminated. There's not even a right to counsel if you're going to jail for not being able to pay child support. That's sort of the environment in which we're operating. You know, in contrast to in criminal cases where the court has recognized a right to counsel for people facing incarceration. They had a very sort of dim, narrow view of civil cases, not really considering them to be as important as criminal cases, despite, again, parents losing their children forever. And even people going to jail, even though it's the same consequence as in a criminal case, they've found ways to sort of distinguish those two things. What that's led to basically is the vast majority of civil litigants do not have counsel. And basically, you know, even those who actually make it to legal aid, who understand enough to go to legal aid and ask for help, half of them get turned away because legal aid doesn't have the money. And the reason why they don't have the money is because to wherever there is not a right to counsel, there is no obligation for the government to do anything. So whatever does happen happens because the government feels like doing it. It feels like funding it. And that That changes as political winds shift. You know, the funding goes up and down or disappears entirely. There have been times during some of the presidential administrations where presidents have proposed zeroing out legal services altogether, you know, completely eliminating it. So we basically, this is the laboratory in which the right to counsel movement grew, which is a very difficult one. And one stat that's not up there that's really compelling is that the National Center for State Courts found that 3/4 of all civil cases across the board involve at least one unrepresented litigant, at least one. And we know in a lot of cases, there are both sides are unrepresented, like in custody, that's very, very common. So we're dealing with, you know, a crisis of epic proportions. And that problem certainly did not get better with the advent of COVID-19. As Delegate Rosenberg said at the top of the hour, don't waste a crisis. We did not waste this crisis. And unfortunately, race equity matters are kind of significantly worsened by this access to justice crisis. It's not felt equally by everyone. And this is just like a statistic from here that basically Black women face eviction almost 4 times more often than white renters. So when you don't have when no one has counsel, the people who are in those proceedings more are going to feel the impact of that lack of counsel more. And that is not just housing. We see that disparate impact across all the civil areas that we work in. There are other sort of considerations that make the access to justice crisis worse from a racial equity lens. There are certain cases where I just mentioned evictions, but in foreclosure and immigration, family court, these are all areas where people of color show up at disproportionate rates. So the lack of counsel is a particularly nefarious problem. So then we shift into, okay, so we understand there's a big problem. Why right to counsel? Like why this response? Like there are many things that people talk about doing as a way of solving that problem. So I'm actually going to turn it to Amanda, who's going to just talk a little bit about what do we mean, first of all, when we say right to counsel, because if you don't know what that is meant in the sense of the movement, then there can be a lot of confusion as to like what we're actually seeking to accomplish.
Yeah, thanks, John. Good morning, everyone. I'm so glad you could join us today to help us celebrate our 20th anniversary. So before we get into the next portion of the presentation, which goes into a bit more detail about justifications for the right to counsel and the current landscape of the right, as John mentioned, we need to understand what are we referring to when we talk about the right to counsel. And so we really mean a government commitment, right? So some kind of enactment, something enacted in the law, not just increased money or appropriations for legal aid to provide more, or legal services providers to provide more representation. And we believe that that's truly important because it sends a really powerful message to the community that the government is committed to kind of equalizing power in this system. And in fact, when the NCCRC works with City Health, which you'll hear more about a little later in the presentation, we work to grade or give medals to cities to kind of rate where they're at in terms of the eviction right to counsel. And in doing that, we don't provide medaling to cities that don't have an enactment in the law. Public funding is also a really important component of the right to counsel. It tends to be more sustainable, more reliable than private funding, more permanent. There's more accountability there. And finally, the right to representation has to be provided to all eligible litigants, right? And eligibility can be based on income, for example, 200% or below of the federal poverty level or 80% of AMI. It might also be tied to geography, maybe in the early days of the program being rolled out. There might be certain zip codes that are targeted and prioritized, or even certain demographics, whether it's seniors or disabled individuals. So it's not necessary that all litigants receive representation. There may be some eligibility there. We're also referring to full representation, right? So not making decisions about who gets services based on resources or resource constraints. And so that's also a really critical component that distinguishes the right to counsel from other interventions. Finally, when we talk about the right to counsel, we're not talking about all civil cases. We're really focusing on basic human needs, as Maria mentioned earlier. So shelter could be foreclosure or eviction matters, sustenance, public benefits, health, safety, like domestic violence, orders of protection, child custody and abuse and neglect proceedings, termination of parental rights, and things like that. And we also really defer to the locality that we're working with. You know, if they say something is important to their community and it's a basic human need, then, you know, that's something that's considered. Yeah, and so the eligibility for other kinds of cases, you know, there are exceptions. I mentioned income being a common metric, an objective one, right? But in other case types like mental health, for example, guardianship cases, there may not be, or representation for children in abuse and neglect, those might be kind of unqualified, not based on any kind of income eligibility. And increasingly, there's a push in eviction cases as well for universal representation. So now that we have a kind of a common understanding of what we're talking about when we refer to the right to counsel, I will send it back to John to talk about the justifications.
Thank you so much, Amanda. And you know, there are a lot of misconceptions out there about what the movement is seeking. You'll see them in the press. The people who are not fond of right to counsel will often say things like, you know, they're trying to get it for all cases all at once, or you know, or whatever, or you know, whatever the sort of allegation is. We have to basically say, like, that is not what we're seeking. It's an incremental approach. Like, we're looking issue by issue, city by city, state by state, working with the jurisdiction to say, what do you need? Like, what do you need from us to help you achieve your goal? Not what do we think you should be doing, but how can we help you achieve your goal? That's our purpose for existence. And with respect to the eligible litigants, that's also really important, because sometimes advocates will think, well, if we can't get a right to counsel for everyone, we shouldn't do it. And it's like, well, actually, no, that's really not necessarily true, because you can start with a more limited right to counsel. And then as time goes on, you can start stripping those limits away. The success story from Louisville was, first of all, that they are now using general revenue, not ARPA money that they convinced the city to, which was always the plan when they passed it. And that's another thing we often say is, like, if you can get temporary money from the government, we can work with that. We can build the advocacy. You've got to get the program in place. You've got to build the infrastructure, show it works, and then we can go from there. And the second success story is that there's been a bill filed to strip away the families with children requirement, so that it would apply to all tenants, at least still at that income level, but at least it would remove that requirement. So they're basically building little by little, which is exactly what we tell people to do. You know, don't feel like you have to get it all or go home. That's not the approach that we advocate for. So there are a lot of justifications for right to counsel. I actually saw someone put in the chat, it's a moral issue, without a doubt. You know, what we are, the number one reason why we're doing this is because the issues at stake here are absolutely vital ones. They are the things that people cannot live without. They can't live without their children. They can't live without a home. They can't live without basic sustenance to keep them alive. That is what we're fighting for. Like, that is the reason this movement exists. These are not less important than criminal cases. They are every bit as important as criminal cases. So we really, that is the crux of why we're doing everything we're doing. There are, as we talked about before, like, there are significant race equity considerations in doing this work, which are very powerful motivators for us and for the people in the communities, recognizing the degree of disparity. And besides race equity, there are other imbalances of power. As I mentioned before, at least 3/4 of civil cases have one unrepresented party. In some proceedings, the imbalance is wild, like in eviction cases where it's 81% of landlords, 3% of tenants. When you have that level of imbalance, you're talking about a system that will basically adapt itself to basically serve the needs of the party that's represented. Those attorneys who are repeat players in the court, they know how it works. The judges are friendly with them. The system basically works for them. It does not work for the people who don't have counsel. And there's actually an expectation that the proceeding will go very quickly, because the side of counsel will just sort of get it done. The other side may not even be offered an opportunity to present their evidence. So these are, and in many of the cases that we work in, the opponent is the government, and the litigant is, the litigant who has no background in law or anything. English may not be their first language. They may have disabilities that further impact their ability to self-advocate. So the imbalance of power is just massive in so many of the issues we work in. And we have seen that, like, some people will say, well, why don't we just let courts decide when to appoint counsel? Like, they see the case in front of them. Why not let them choose, like, when to appoint? It is an epic disaster. Like, we have seen that in practice. The judges do not have the information in front of them that they actually need to know whether or not the person needs counsel. They are not allowed to investigate the case. All they know is what the person brings to them, which often is not, the person does not know the relevant facts and law that they need to tell the judge to make them see it's a meritorious case. The judge will just think there's nothing to it. It's really simple. Everything they're saying is irrelevant. Clearly a lawyer would not change that. So that system does not work. Also, in many jurisdictions where judges are elected, there's a lot of pressure on them to not appoint, because if they do, that every appointment comes with a cost, and then that can come back to bite them in the next election. So it does not work. And there are many places in the country where they have a discretionary appointment counsel system by law, and it does not work. That's what we've learned from talking to people in those jurisdictions. We also know that when right to counsel is in place, system actors change their behavior. We see in the housing world, we see eviction filings go down. In the child welfare context, we see fewer cases that are, fewer petitions that are being filed seeking to remove the children in the first place, or instead of seeking removal, they might seek supervision and planning instead because of that intervention of counsel. And on and on and on. We just see the actors making different decisions about how to proceed because there's a lawyer actually advocating on the other side. So there are more things we could talk about, but in the interest of time, we really need to just keep moving. But suffice it to say, there are a lot of reasons why. I do need to mention two more. One is that there are significant financial benefits of providing counsel. Study after study has shown that governments pay tremendous amounts of money in all the wrong ways. Basically, we pay for the downstream consequences of all these civil cases, like evictions. We pay for homelessness. We pay for mental health. We pay for incarceration of homeless people. None of those things make sense when we can stop those from happening. And in fact, not only do they not make sense, but they cost more than the lawyer would have, like all of those downstream interventions. And it's the same in all of the other civil cases we work in. If you don't, like for instance, with child welfare, the cost of foster care is astronomical. In basically all these different areas we work in, there's always a consequence that the government and the taxpayers will ultimately wind up paying if there's no intervention. We now have the benefit of more and more studies that show this, which is extremely helpful. And then lastly, it works. And really that is for us an extremely high priority for why we do this work. It is an evidence-based solution. There are a lot of different things that are being proposed right now about how to deal with the crisis. Like everyone is coming up with different ideas. We should have like more hotlines, we should have more help desks, we should have more technology, we should have more this, more that. We need to see the proof that it actually will change the results in court, not simply that it will let more people participate. Participation is great, and that is an important part of what we do. But participation alone is not the metric. It's actually what happens to those people who participate. And until we see the results of those other interventions, until we start seeing the data on what impact they have on outcomes, we know right now that full representation makes a difference in outcomes. We have studies going back for decades that show that that's true. And now we have the data coming out of right to counsel programs that's also proving, in case there was any question, if you represent everyone, you will get an impact across the board. So we have, these are just like an example of some statistics from some places, that show, and we're going to talk about housing in specifics. We have, those statistics, but it goes up dramatically in immigration cases. It goes up dramatically in DV cases. It goes up in public benefits cases. Just across the board, we've seen this evidence. It works. Really, the hesitation has always been the cost. And as we said, when you realize that the cost is so much worse to the government by not acting, that argument really just doesn't make any sense. This, just to give it some context, these are some statistics that were run to look at the total cost of eviction in the United States, and it basically, predicted that evictions cost $315 billion a year. That's, this does not even have all costs that are attributable to eviction. This is just including shelter and medical care and child welfare and delinquency. There are many, many other things that are not in that chart. A right to counsel, if we provided a right to counsel for everyone in America for tenants facing eviction, it would cost probably in the neighborhood of about $8 billion. And we're spending $315 billion to deal with the problems of eviction. So it just gives you an idea of like penny wise, pound foolish, like this, not providing counsel is. So that's where we were. That's the justifications. Now we're going to say like, okay, so where were we before we started all this work? Basically, we did have a right to counsel in every state. Every state did provide it. It was patchwork. Newsflash, it still is. But and basically where we were, and some of this we're going to talk about. We've improved these areas, but it's still a case. The majority of states do provide a right to counsel for matters that involve children being removed by the state for certain proceedings involving mental or physical health. Those are things that the states do pretty well on. You can see where there's an asterisk that Maryland itself does provide a right to counsel for that kind of proceeding. So there are some areas where the states do pretty well. This is also one of the myth busting things. Like you often will hear the press will say, because there's no right to counsel in civil cases. Like, no, that's not right. There is, there always has been. It's just limited. And we're getting better every year. And then there are some areas where the states do pretty well, but we still don't have a majority. Again, you're looking at a lot of health and sort of family law sort of matters. And then basically few or no states, custody, domestic violence, public benefits, until we started doing our work. Housing was on that list too. Again, we're improving these areas, but it is still the case that this is the landscape that we entered when the organization began its work. And so that's why this is a view from our website where you can see a color coding of like, this is, an area. So you have like termination of parental rights for parents' right to counsel. The green is a good thing. Green is good. And then you have tenants facing eviction, which is the purple. A lot of the purple is because the whole state doesn't have a right to counsel, but a city within the state does. And you can see some states are actually green because they do have a right to counsel. But so we're that's where we're making a lot of ground. And then you look at like, for instance, healthcare access, where we're basically nowhere. So like this is where it shows we've done a lot. We still have a lot to do. So what are we? How did we get here? And what are we? What have we accomplished? So basically, historically, the coalition came into existence because of a case right here in Maryland called Phrase about the right to counsel for parents in a private custody dispute. The court did not rule on the issue. It avoided it by ruling for the Public Justice Center's client, but said that 3 of the 7 justices, including Judge Bell, who was the chief at the time, said we would reach this issue and we would find a right to counsel. The time is now. Because of Phrase, there was an interest, and there was at a conference, a national conference, there started to be a conversation about should we be like trying to advocate for this on a more cohesively, in a more organized way. And that led to 5 organizations, of which PJC was one, to come together to create the coalition in 2003. Deb Gardner, who was the litigation director at PJC, was the coordinator for the first 6 years of the coalition's existence. And as we mentioned before, the ABA provided my position initially, and then Open Society and Ford provided the initial funding. So that was all how things got kicked off in that time. As we mentioned earlier, the ABA resolution, this is you can see the list of co-sponsors there. This was in 2006, so just 3 years after the coalition got started. This was what helped sort of keep things moving forward. And then where we are today, as Maria basically said, we have 600 participants in 45 states. When I started in 2009, it was about 180 in 30 states. So we've dramatically grown in that time. And we've really grown like this sort of breadth of people who are involved. Like we have a lot more organizers and community-based organizations involved now than we ever did before. We work with the access to justice commissions, the legal services providers, the private bar. A lot of policymakers reach out to us directly and ask us to provide TA to them, which we do. County officials, city, state, housing departments, et cetera. As said before, we take a state and local, we're both state and locally driven, and we have an incremental approach to the work. The areas that we do the most work in are eviction, domestic violence, guardianship, and child custody. Those are the ones that come up the most, but they're not the only ones. We've done work around fees and fines, incarceration. We've done truancy has come up for us before, all sorts of like involuntary mental health treatment. These were all, in fact, that came up here in Maryland. So there are all of these issues that we work in, which you can imagine is a lot. Like there's a lot. If you see the full list of civil areas, it's like 30. There are many, many civil things that fall into the civil camp that we cover. So how we do that basically is we coordinate and support right to counsel advocacy nationwide. We gather, as Maria said, we are the hub for right to counsel information across the country. We have a one-of-a-kind status map where you can see in a click of a button how all the states are doing on right to counsel, where all the current initiatives are. We have memoranda on all the subject areas, all like basically what the right to counsel is and isn't in all 50 states. We produced a similar guide for judges, like basically as a bench guide for them. We work with the EBA to produce that. We then work directly with jurisdictions trying to pass legislation. We do everything from helping them figure out like what's going to be in the bill to who the opponents are going to be and so on and so forth, all of like soup to nuts, basically on what they want from us. Like we don't, again, it's a partnership where they say, here's what the support we need from you. Litigation also, anytime there's a right to counsel case anywhere, we're going to be involved with it because those are so high impact. Those we're talking about appellate cases, not trial level. Like we deal with only appellate litigation. And there are always cases happening all across the country. You'll see some of those. We do data analysis of like that's coming out of the programs about like how successful they are so that we can make sure people understand that and are able to digest it. Some of these reports are 70 to 80 pages long. So we kind of distill that down for people to make sure they understand what the impact is. We develop partnerships with influential organizations like the National League of Cities, the Federal Reserve, the Salvation Army, and so on. These are very strategic partnerships. These groups have a large audience that we can reach, and then in turn can become advocates for the cause. And we serve as experts for the media. This is just a splash of some of the litigation that we've done recently. It's not everything, but one of the things that always excites me when I look at these lists of legislation and litigation is when we look at the spread of jurisdictions. It's people think, oh, right to counsel is a California thing, that's a New York thing. Well, no, it's an Alaska thing, and it's a Michigan thing, and it's a Maryland thing, and it's a Pennsylvania thing. And we've litigated in Montana, and we've litigated in, I think North Dakota, and like there's litigation has come up all over the country. It's not just East Coast, West Coast, as people will think. As you can see here, the 2 stars indicate successful resolution of the case, meaning the right to counsel was established. So we've had some really good success on these issues over recent years. And you can basically see we're involved in almost all of these cases because we view them as such a high priority that when they happen, we will just drop everything and sort of jump in because they're on a timeline and they're really important. Legislation also, really, again, we'll get to housing in a minute, but this is just a little sampling of like some of the legislation we've seen in recent years: adoption, domestic violence, civil forfeiture, immigration. We could have a lot more on there. We just wanted to give a sample of like, again, it's coming from Arkansas and New Mexico and Arizona. Like these are reforms coming across the board. Interestingly too, we have some unusual allies in some of this work. Like when it comes to like civil forfeiture, very conservative groups don't like government interference. They feel it's overreach. So things like when the government's seizing property, they don't like that. The Institute to Justice, which is a conservative think tank, is one of the leaders on both fees and fines and civil forfeiture work, and including right to counsel. So, we do find partners in some of this work that can really help advance it. And then we're going to get to housing. Make sure I leave enough time for housing because housing is really a really huge area for us right now. But we would be remiss if we didn't note that guardianship is increasingly becoming a major area that the states are looking at reform. The issue with Britney Spears in California, where she couldn't get rid of her guardian, became a national issue, and it really raised the profile of many problems, including the problem of the right to counsel. Some states do not provide an attorney for someone who's being subjected to a guardianship, even though that literally takes away every right the person has, where they live, who they talk to, what medicine they take. Everything is controlled by the guardian, and they may not have a right to counsel for the hearing. And in fact, in some states, there isn't even a hearing. There's just a petition and the court will sign off on it without a hearing. There isn't even personal service in some states about the guardianship, which is blows my mind. I mean, all of that is unbelievable. But there's a lot of work to do in the guardianship space, and a lot of states have been introducing bills to try to close the holes, including right to counsel. Child welfare and really child welfare and child custody cases have been really dominant. You can see here just a lot of legislation and litigation over this that we've been involved in over the years, all over the country. Amanda, who is currently dealing the flood of bills that come in January, can attest to how many bills we've been seeing coming in every day. There are basically about 200 bills filed a year on right to counsel, and a number of them, a good number of them, are in the family law arena. So we monitor all that, we report on it, we fight the bad bills, we let people know about the good ones. Part of our role is to make sure that people know about the bills, because in some states, advocates are not aware a bill got filed. So we will actually call them and say, did you know there's a bill about this in your state? And they'll say, actually, we didn't. And so that's part of our role, is to keep people informed of everything. So where we're going to turn now is the right to counsel for tenants, because that is what has really, in the last 5 years, dominated so much of our work for unsurprising reasons. It's just worth mentioning before we get into it. We talked about the justifications for right to counsel in evictions. We often have to make the case on, I think, another level, because there's such a perception that, oh, these are just simple, straightforward cases where people didn't pay their rent. So what is there to talk about? Why do these people need a lawyer? There are actually many, many defenses available in eviction proceedings in not every jurisdiction, but in many jurisdictions. And some defenses are available in every jurisdiction. If the eviction isn't filed correctly, if there's a fair housing violation, if there's if the person did pay but the payments were not credited properly, these are available in any jurisdiction. And the lawyer, without a lawyer, it's extremely hard, unlikely that you're going to prevail. And then with COVID-19, there have been new protection states have put into place that we've seen already that many of them are going unenforced without counsel, where there is no right to counsel. Like they may say, like, you know, the landlord has to attest that they applied for rental assistance before they file the eviction. And they're not, they're just filing evictions without doing that. And judges will not stop them. They do not read these complaints and then say, oh, you didn't follow the rules. It's not how it works. This is relying on the tenant enforcing their rights. So, and then even where the tenant has to leave, the court has to determine how long are they going to get to go before they go. Are we going to enter this eviction on their record or not? And how much of a rent arrears judgment are they going to have? And those things are the difference many, many times between whether they become homeless or not. If those decisions all go the wrong way, there's a very good chance they will not be able to secure any future housing. And then when you add remote hearings on top of it, which many tenants don't have access, they don't have the tech, they don't know how to use it. And then rental assistance, getting rental assistance and applying and actually getting it, even if you get it, getting the landlord to accept it. Some landlords are refusing to take it. That's much less likely to happen if the person has an attorney. So these are all things that are justifications. And then even before there was a right to counsel anywhere, we had data showing like the kinds of results that happened from places that expanded representation. Tenants were likely to stay in their home. They were less likely to be subjected to a writ. They were 4 times less likely to use a homeless shelter in Minnesota. You know, so these were all positives that we knew came out of increased representation. And all of this, everything you've heard today drove the movement, which, as you can see, 2017, New York City was the first place to pass a right to counsel. It was a tremendous tenant organizing effort in New York City. They have an amazing coalition there that really drove the train and got it done. And you know, New York City is investing something like 186 to $200 million a year for its right to counsel for tenants. They've hired about 800 lawyers because that's what New York has, like 200,000 eviction filings a year. So it's just like and that's just the city. That's not the whole state. So New York City was first. Obviously, getting a city of that size on the board was hugely impactful. And we did, you know, we were involved in the New York effort. And then even before New York passed, some places like San Francisco started getting it going. And then they passed it by ballot initiative in 2018. And then Cleveland and Philly. And then when the pandemic hit, we were really worried that was going to be the end. Like we thought, oh, these states are never going to spend $1 on this issue now. Like they're going to be so panicked about their budgets and COVID and everything. And as you can see in 2021, that did not happen. 2021 was an incredible year where 6 cities and 3 states passed a right to counsel all in 1 year. That was not an accident. It was the result of advocacy from so many people around the country that we worked with that were incredibly effective at what they did. 2022, we saw 2 war jurisdictions pass. St. Louis just introduced the bill last week. It's actually has a hearing tonight that I'm going to be testifying at. And we've already seen, I think it's somewhere between 6 and 8 states file a bill this year already. We know at least another 3 are coming that we talked to advocates about. So there is just tremendous momentum on this issue right now. And as I said, organizing has been one of the biggest reasons why it's getting such traction, is because tenant organizers, A, decided that right to counsel was a priority for them, and B, are extremely effective with what they do. And in the places where organizing has happened, the right to counsel has actually been stronger. The bill that's passed and the implementation has gone much more smoothly than in places that don't have organizing. This was a cost saving estimate that was done in Baltimore prior to the passage. So both Baltimore and Maryland passed a right to counsel for tenants, and this was a report done by Stout. They've done reports they're an independent analysis company. They've done them all over the country, and they found that a $5.7 million investment would result in 35.6 million benefits to the city and state. Those cost studies have actually been very helpful in convincing some reluctant policymakers to do this. And then there have been more of these other ones that New York City, Philly, and LA all had basically numbers saying like, this is going to be huge if we pass this. Like, this is going to save a lot of money. And it's going to save way more than it costs. One other thing that is like really amazing to me, and this I think, coming from when I started in 2009, I don't think I'd ever thought I'd see numbers like this. But when you see the public support for right to counsel, this is eviction specifically, that basically no matter which political party you ask, basically the majority supported either fully or somewhat a right to counsel for tenants facing eviction. And in Maryland too, like those are really staggering numbers, and it really shows how much work's been done to change public opinion on this issue. Even outside of evictions, there's been polling done on civil cases generally, and the majority of people support the concept of right to counsel for civil cases involving, basic human needs. So it's not just we have the data, we have the public opinion, we have the media, which has also been a huge player on this. I'll get to that in a minute, but one of the things that's also really nice is seeing it's winning over the judges who were very reluctant on the right to counsel and evictions. That in New York, they testified it's actually made things better for them, not slower, not worse, which that kind of testimony is absolutely invaluable in convincing other jurisdictions not to put the brakes on. Unfortunately, in many places, it's the courts, not the landlords, that are actually making it hard to pass the right to counsel for eviction. Let me put it this way, the landlords are not helping, but they're not as big an obstacle as the courts sometimes are, which is really interesting. A lot of landlords are coming around on right to counsel. They are, I don't remember if we have the slide or not, but in New York State, the Real Estate Board of New York submitted testimony. They have a statewide bill pending in New York State right now, and the Real Estate Board submitted a letter in support of the right. So we've heard before landlords support right to counsel. We've never been able to get them to go on the record. They never are willing to say it to the press or to us, like in a way that we can write down. It's always like in private conversations, whatever. But this is the first time that they've like gone on record, and obviously a big entity like that's huge. Like we mentioned before, we see right to counsel changing the system. In New York City, the filings are down, the defaults are down. The same in San Francisco. These are powerful numbers coming out of these programs. These were like 2 of the earliest ones, so this obviously added a lot of fuel to the other places that came after it. If their initial programs weren't succeeding, it would have been really hard to keep the movement going. But the success coming out of those early programs really drove the train. And increasingly, we're seeing that now from some of the later implemented programs. Some of these numbers are really, staggering, like Kansas City seeing a pre-eviction rate of eviction rate of 99% going down to less than 20%. Cleveland seeing results really positive on a number of fronts. Like I love the rental assistance one too, that like tenants did not know about rental assistance before they contacted legal aid. That legal aid was the entity that made them aware of it, and we're the ones that helped them secure it. So really like showing this actually has multiple benefits, like the right to counsel kind of inadvertently causes other collateral benefits to accrue. And in Cleveland, it's also worth noting that 42% of the tenants who legal aid work with did not want to remain in their homes, which is why the focus in some jurisdictions is not, let's keep everyone in their home. That's not, it's let's do what the client is actually trying to get. And let's focus on what is going to be best for their long-term housing stability, like in working with the client to arrive at that position. So in Cleveland, where that was not the goal is get the eviction off the record, get them the time, reduce the arrears, get them a clean move out so that they can find new housing and have better chances. This is just a sampling of some other places where right to counsel efforts are happening. This is a very small sample. We're probably in like 30 or 40 jurisdictions right now, city, state, county, at least. It's probably even bigger than that at this point. But just a really diverse, sort of list of places when you look at it. A lot of like small places that you would not think about working on this will call and ask for help to get things started. I would say that the press has been really helpful too. We have had so much press coverage of right to counsel in the last 3 or 4 years, both from the local press outlets, but also from like NPR and the New York Times and the Post. And the Washington Post run an editorial series on right to counsel that they wrote 4 articles in a row about different civil areas, which was incredible. We're actually able to work with them on that series, which was great, help them steer them to what issues they should cover. And that coverage has really helped keep the drumbeat going, like keeping the pressure on, keeping advocates aware this is an issue. And also a lot of local press coverage too. Whenever there's a right to counsel bill that makes progress, we see a local story about it. It's the press are aware of this issue. They're really keeping the pressure on, which is great. We also started some great new work this past year. One is with an organization called City Health that basically tries to get cities to pass policies that will advance health. And they viewed right to counsel. We had a lot of conversations with them. They were interested in tenant representation. We actually convinced them it should not just be representation, but right to counsel that they should be advocating for. As a result of working with them for over a year, we developed this criteria for how to grade the cities in their cohort. They have 75 cities in their cohort on whether or not they have a right to counsel, and if so, what grade it should get, essentially. And so we made the rubric pretty strict because we're trying to push the cities hard on this, which is why only 2 cities of the 15 that have a right to counsel got a gold medal. In fact, some of the ones that didn't have already reached out to us about the fact that they didn't get a gold, and so they care about these medals. And in addition to that, we worked on a report, a comprehensive report that we co-authored with Enterprise Community Partners under City Health's banner. That was basically talking about how this is a health issue, how it's an equity issue, and everything else. So and now actually their policies just got released last month. And so we're just starting to get the feedback. We're going to be working with City Health all year on the cities that contact them and say, we want to get a medal. City Health actually gives an overall medal to any city that gets 5 medals. They have a package of policies, right to counsel is one of them. And any city that gets a medal, any medal in 5 policies gets an overall medal, which cities really want. There are some cities that have 4 medals right now, and right to counsel could be their 5th one. So it is a leverage point for us. And then another really massive collaboration over the last year is with this entity called Results for America, which also focuses on getting jurisdictions to pass policies that will advance, good causes. They've worked on, I think they've done, Mayors for Guaranteed Income in the past. And so they reached out to us initially. We negotiated with them for a long time on this project because it's a lot of work. I'm just going to say right now that Maria was the point person on Results for America and did an unbelievable job getting us to the finish line in our first cohort. We had 38 cities apply to be part of a cohort to go through this boot camp on right to counsel. We took 13 of them based on our evaluation of their teams. Their teams had policymakers, they had legal services programs, organizers, and other people involved. It was a great thing. We had like 100 people basically participating on these Zoom calls for 8 straight weeks. And we're already seeing St. Louis was one of the boot camp, and they've already moved, and we're expecting Pittsburgh to do so, which was another city. And all of them came out with action plans, which was part of the requirement for participating in the boot camp. We just worked out that we're going to be rerunning the boot camp with Results for America this spring. with another set of cities. So we're really excited. It really has become a model for advancing the right. Like it's basically just like, because all the same questions come up all the time. So this is a way for us to get those questions answered. And also politically, a lot of these teams are inviting like policymakers or other strategic people that they know they need to convince. And they're using the sprint as the mechanism to do that, which is exactly what we wanted. Like, so some of them, like they already, the team leader already knows all this stuff. They're just using it as a leverage point, and that's working. It has been working really, really well. Some of the teams had almost all government people on them, like, which was incredible to see. And they were there, they were showing up week after week, going through the training. So we also were fortunate to work with several other organizations, PolicyLink, Redbridge Strategies, and Heartland, basically to contribute on organizing. Heartland is a legal services program. Redbridge is an organizing consultant. So and PolicyLink just does everything on housing. So it was really a collaborative effort that helped so much in getting these jurisdictions moving forward. And here in Baltimore and Maryland, the implementation efforts are underway. We are, as Delegate Rosenberg mentioned, there's still a fight to get funding for the right to counsel in a permanent sense. There's been funding for FY24 that's been put aside. He's got an effort going to try to find additional funding, but that's obviously critical. We can't have the program. There has to be sort of an ongoing permanent source that's identified, or the general revenue is there's going to be a commitment of general revenue. As with other places, the organizing was really critical to getting right to counsel passed. Baltimore Renters United for Baltimore, Maryland for the state level effort would not have happened without their pushing the city and the state to adopt these policies, without the champions in Annapolis, without the legal services programs being supportive of it, and the Public Justice Center, not us here, but the staff of the human right to housing staff at PJC were huge in getting the right to counsel passed. So just so many people involved.
I'm just going to add
Yes,
really
please.
quickly. So Matt Hill, who leads the human right to housing team, of course, at the PJC, his team was really behind what happened in Baltimore City and in Maryland, along with, of course, BRU and Maryland Renters United. So he couldn't join us today because he's doing the work on the ground, and his team is as well. But he did just want to highlight, Cherie Slew, who is a former PJC staff attorney, was on the Access to Counsel Addictions Task Force and really led some of those initial implementation efforts as far as the PJC was concerned. And then he also just wanted to highlight, the work of BRU and Maryland Renters United, of which PJC is a part, just to really acknowledge that it's like coming from Maryland and Baltimore. Which also Delegate Rosenberg mentioned at the beginning, Maryland is has always kind of been at the helm of this discussion around the civil right to counsel. Like they had their own kind of way to go about this and try to really expand that nationally. You can see that from writings from our former executive director, John Nethercutt, and Deb Gardner at the very beginning, in the early 2000s, around phrase that there was a Maryland kind of strategy around how to explode this nationally. And it's really cool to be housed within this state and within Baltimore and the PJC. We're gonna look ahead just a little bit. So what is coming up next for us? We are thinking more and more about what it is that our coalition participants need. There are so many tools within the right to counsel for tenants facing eviction that are already available and that we've also already developed, but we're producing more and more. We are, of course, advancing housing justice. The right to counsel for tenants is going to run its second iteration in the spring. So that's a huge lift for us this upcoming kind of first quarter. But we are hoping that you will think about and keep in touch with us about a possible convening in the early fall, where we can all get together kind of in person to talk about these issues in more detail.
Yes, and a lot of research coming in this coming year. We have a lot of, Amanda has been working really hard on some of the issues that people want to know more about. People want to know, how do I run a ballot initiative effort? We're going to have something about that. We're working with PolicyLink on that. We have something about some of the legal issues that people run into when they try to pass it at the city level. There's sometimes the cities will be legal objections, so we need to be ready for that. And we have a memo that we're working on that. and a variety of other things. Like, and we also, one of the biggest products of the year is going to be a guide that Maria is really coordinating, that basically is going to be kind of like the sprint, the boot camp, but like a written form to like provide a lot of information in written form, answering the questions we hear a lot of the time. We actually have interviewed all of the jurisdictions that passed a right to counsel, all 18 of them. We worked with a law firm and a law school to interview them all, ask them questions about how they got it done. We don't want to lose the memory of the campaign and how it was run. And we're about to do a second round of interviews of them on implementation, how they're actually getting, like how they're actually doing, how things are going, making sure we understand the details that don't get reported. We do work with them regularly in these things, but there are a lot of details we don't think to ask them all the time. So this will get it all down in memory. And all of that information will be in some way incorporated into this massive guide that we're working on. So we have a lot of work product coming. We've been working on it for a lot of 2022. Hopefully by the summer, it will all come out as a package, and the new website, which also is, which is going to better integrate the legislation stuff into, among other things, into our website. So we're going to stop there because that was a lot of information. And just thank you so much.
Once you get him going, he will not stop.
And I'm from New York. So I may live in Alabama now, but I can talk when I need to. So we wanted to give folks a chance to ask questions. For folks on the Zoom, if you wouldn't mind just putting them in the chat, and we'll sort of get to them there, and then we'll ask questions. We'll start with questions in the room, and I see Ronnie has a question.
Yeah, where do the lawyers come from?
Oh boy, that is the question, isn't it? We didn't actually mention that, but one of the biggest challenges facing civil legal aid, not just right to counsel, but civil legal aid right now, is the hiring of attorneys. A lot of programs are finding it very difficult to recruit and retain lawyers. We definitely are seeing that in the right to counsel world too, where some programs are already worried prior to passage that they're not going to be able to retain the sufficient number. And I'll just say before I get to where they're coming from, the first response to that is right to counsel, just like we said, it can be incremental on the scope, it can be incremental on the rollout. And we encourage that, take as many years as you need, just get it on the books. If you need 5 years to get it all fully implemented, because that's how long it'll take you to get enough lawyers, then that's what you need to do. But don't lose the momentum we have right now and put off passing the ordinance because you're concerned about that. Like get it started and look at your business plan for your organizations and say, like, how many attorneys do we figure we can hire each year, and then build off of that. We actually are going to be doing some work with any luck and the support of one of our funders. We're going to be turning more work to the pipeline, trying to get into the law schools, trying to work on them more about the kind of students they're turning out, getting, whether that's like adding more access to justice material to the curriculum, whether it's developing more law school clinics, but just really trying to crack that problem from that end. Some of it has to be done from legal aid's end, like the pay equity is a real problem, like the pay is so low that a lot of them will not go no matter how convinced they are of the cause. And that's something that I think a lot of programs are starting to review. When right to counsel passes, one of the things that's absolutely essential is that enough money is appropriated so that the programs can hire and not overstaff, not have the staff overburdened and overworked so that they feel like they're miserable. So all of this kind of connects. Like, we can do some work on the front end when right to counsel passes to make sure that enough funding is appropriated for that. But then in terms of, again, hiring the lawyers, there's still a lot of work institutionally and then from the law school side.
Yeah, can I ask a follow-up as a person at legal aid whose attorneys are underpaid and burned out? Are there examples where this has happened and you've had a strategy to shore up the funding? And not only just the funding, but I worry that localities will use the failure of the program because lawyers aren't joining to prove that we don't need it. And I hear that a lot from my attorneys, and I'm terrified of it because I totally agree with the keep the momentum going strategy, but what are the nuts and bolts of keeping the momentum going? And we don't have to hash it out all here, but I would love to work more, and obviously we'll be in very close touch about models and best practices for making sure that we do close that gap, because right now it is hard.
Yeah.
One of the, just really broadly, just how the NCCRC plays into all of that is one of our roles is not necessarily to solve, but to coordinate and collect
Yeah.
possible solutions or
Exactly.
or right where
Sure.
folks have come up with strategies. And so we do that, at least for the implementation front. We have like a implementation working group where right to counsel, people who are involved from legal aid, or maybe they're people who are implementing the right to counsel across the US in the right to counsel for tenant for tenants facing eviction proceedings specifically. That's what we're doing, is kind of, we hold the group, we hold space for people to discuss strategies. We make sure we record all of that information so that folks have it for like long-term use. But really it's just the coordinating and connecting of jurisdictions so that we can all come up with solutions together. And then another way that we do that is like the interviews, right? So like pulling apart strategies, because this is, at least in the right to counsel for tenant space, like this is new. Like it's 2017 was the first year, and New York is only now like really like feeling kind of the challenge and working through the challenge and trying to figure all of it out. So it is a learning process. That is not a reason to give up on it.
No.
And I think like from the leadership level, like we have to keep the whole.
I appreciate that. And I actually have to run, I've actually run to Annapolis to beg for the money
Yes,
to make
go
up.
ahead.
things. But yes,
Go ahead.
Thank you very much.
Thank you.
And one more thing before you go, which is I forgot to mention that we run a monthly call focused on implementation for advocates around the country.
Oh, that'd be great.
And one of the questions we've had people present on is the pipeline issue,
Yeah.
to talk about what they're doing. We heard from like Milwaukee and one other jurisdiction about like some of the things they've started to attempt to try to open the pipeline
That's
up.
great.
Yeah.
That's great. Okay, well, we'll be in touch. Thanks,
Absolutely.
everybody.
Yeah.
Really appreciate it.
I also, it's worth mentioning that, New York City, is really experiencing a massive problem right now, because New York had a lot of protections during the pandemic to stop evictions, and then when those ended, the pipe of evictions just went completely, off the rails, and the courts basically response to that was like, just let them all happen. And the programs were saying, well, wait, we haven't fully staffed up yet. We need continuances, we need more time, and the courts are saying, we're not going to do that. That's obviously a failure from our vantage point of the courts, like their responsibility, because the tenants have a right to have a lawyer there. So the courts proceeding without that lawyer is, in our view, a violation of their obligation. They don't see it that way. And increasingly, part of the issue is to make sure that the press understands that when tenants are getting evicted without counsel, that's not a failure of the program, that's a failure of the system. So like that, there are a lot of pieces to like understanding this how to approach this issue. Other questions? We have a few in the chat. So yes, please.
So I'm Terry Stoudenmeyer with the Able Foundation, and Beth and I are really familiar with all this work. We have funded we funded PJC's advocacy for right to counsel. We funded the Stout study. We're funding Equal Justice Works to work on pipeline issues. So it's all incredible work, and we're so grateful for the work you guys are doing. We met yesterday with an old friend of mine who runs, I think it's called the Institute for Civil Justice at Berkeley Law. And they're working with RAND to try to put on, or they're thinking about doing a conference on eviction prevention, focusing on legal representation. And I think one of their goals is to better engage academia. But listening to you, it sounds like there are a lot of studies already in the works. And I'm just curious if you think there would be benefit in having an academic center do, a big national conference on this.
On the pipeline?
Well, I mean, they're kind of figuring out right now what would be most useful. I think they're generally interested in legal representation in eviction cases.
I mean, it seems like all upside as far as I'm concerned. There's, part of what Maria was alluding to earlier is that, like, when it comes to the pipeline, it's really hard to know who's working on this issue, like, because there's not exactly a place where that work is being coordinated. We're kind of like looking at entering that sphere, but convening where people are getting together to talk about, like we said, this is across civil legal aid. This is not right to counsel problem. This is a civil legal aid big problem right now. And having someone sort of like say, we're going to identify some of the players, invite them to come together and talk. Absolutely. I mean, I think that would be huge.
So just as a little forewarning, you're on their list. They will be reaching out to you, and I think what we'll say is like, talk to John right now. And then another thing that they were mentioning was at the law school level, debt forgiveness and different programs for students being able to go into civil legal organizations and have debt forgiveness. And so that is, as we know, the state, especially, from Maryland legal aid, you have this big debt you have to pay off. You can't afford to go in.
Yeah, and I'll say personally, I had a public interest scholarship, or I wouldn't be here right now. Like, that's a fact. The law school was way too expensive for me to go into. Even though there are federal programs that adjust your payment based on what your income is, those are just your federal loans. Private loans are not subject to that. So, it's if your law school doesn't have something. I had many friends who did not enter this work because they just had too much debt. There's just no way.
Or they had a private litigation career first, and then they did their
Right.
what they really wanted to do.
That's true as well, right? And I think the some of it is also making people aware, like even the federal public interest loan forgiveness program, which I was in to pay for the remainder of my costs. A lot of students don't know about it, or they don't understand what they have to do to qualify. So there's some awareness raising about these things, in addition to there's improvement in creation and also just awareness. Also, I think all of that's needed. And yes, actually, able funding the Stout City again. These studies, we've really seen them be like a major reason why, like the jurisdictions, that reluctant people sort of overcome their hesitancy. So that was a really critical piece of support at a very vital moment. So thank you for that.
We reference it constantly.
Yes.
Honestly, still, there's a lot of statistics there.
As we've said, this is a moral issue, and we never lose sight of that fact. But sometimes we have to speak to the issue that certain actors care the most about. At the end of the day, we can't ignore that. So that's where the Stout reports came from. We have
The last slide. That's what I was trying to click.
Oh, yes. We do have there are a couple of comments about we need to have something to say to judges who continue to tell us that pro se people are doing better, and it's not our job. If they didn't have a lawyer, that's their problem. We need a good answer. I think, the idea, I think that, the best answer to that is the statistics that show what happened to people without counsel. We have, when you look at the improvement in outcomes, those are comparing to people who don't have a lawyer. And they're, in housing, their success rate is pretty much zero without counsel. Like were you gonna?
It's just, that sounds so outlandish for a judge to actually believe that like counsel's not going to help that much, because of how established it is in the criminal world that like if you don't have counsel, you're done for. If you do have counsel, that can be everything. Everyone knows that in the criminal world. Like, how can a judge actually believe that about civil proceedings?
I think in part, again, it comes down to their in the eviction context, it comes down to their feeling like these are all, again, non-payment cases where there are no defenses. In part because they've never seen an attorney argue any defenses. So from their viewpoint, there aren't any. And also not really processing what happens to the tenant after they leave with that eviction record, like not really getting how disastrous that is for them. So a lot of this is education about the consequences of eviction and how lawyers actually intervene to stop those consequences, even if it's not necessarily about the tenant staying in their home. That's an education issue. So it's a great question, and it is an attitude we hear, and we, like all the advocacy we work with, are out there trying to just. Some of this is about education, and some of it is about actually getting it done. But there's still a lot of education. You run into like this, just like people not understanding the way legal aid would actually, what they would actually do in these cases and how they can impact them.
I would just add, it's also a little bit about geography and where those judges are coming out of. Like upstate New York, you don't even have to be a lawyer in order to be a justice, in order to adjudicate eviction proceedings. And those could be, if you're not an attorney, if you don't have that background and you practiced a completely different career, and now you're an elected judicial officer who is navigating those eviction proceedings, you're going to look at that pro se tenant just a little bit differently than maybe a lawyer with legal experience in the past sitting on the bench.
There was also a comment in the chat about funding and being like a lot of options. We actually, on our website, we have this matrix that we keep track of all of the right to councils that are passed, including how they're funded. We update that as funding changes, just to show that some places have gotten creative in how they're doing it. Yes, general revenue is being used. In some places, they're using emergency rental assistance or fiscal recovery money or CDBG. In some places, they have like created a new tax, or they have created a new fee. Sometimes it's like a licensing fee, we just talked to one place where they're using property tax revenue somehow. I still haven't quite heard exactly how they're doing that. In a couple of jurisdictions, they're looking at a fee on the transfers of property, which especially properties over a certain value, so that it basically only hits people who are selling expensive properties. So there are like different ideas, and as we hear about those, we definitely share those with everyone, so that they can just not feel that there's only one, it's just their general revenue or bust. That there are other ways to do it. Those ways come with more objections from the real estate community, of course. But one of the things I love is like in Multnomah County, they're relying on a capital gains tax increase, because the county actually taxes capital gains, and capital gains are not going to be felt by anyone except for most people don't pay capital gains taxes. It's not a thing. So it really helps. They can really just say this is really only going to affect an incredibly small number of people, and so there are ways to find it to where you can really increase the public support for it.
There's a last slide. It has our contact
yes.
information. Please do get in touch. We are very responsive, and we love talking about this and doing work around it. Thank you, John and Amanda, and thank you all for attending in person, and thank you to everybody who attended via Zoom. We're very excited to have done this presentation. Becky, you're the best for setting it all up. Thank you to Brown, Goldstein, and Levy for hosting us. We need to have a photo against this backdrop. Thank you. And Kathleen and Erin, who are in the background here helping us out. Thank you all.